As you're all aware, the passage of legalized recreational use of cannabis in November's election will bring many changes to our state and will undoubtedly impact workplace policy. While we wait for regulations to be passed, the Partnership for Drug-Free New Jersey's Drugs Don't Work in New Jersey initiative will continue to be a resource for information and provide relevant updates to all of members when they become available. That is why we're so pleased to have with us today for this webinar, attorney Nancy DeLue, a shareholder at Littler, Washington, D.C. Nancy is a recognized authority on federal and state drug-free workplace and drug testing issues and has drafted dozens of substance abuse prevention policies, including Department of Transportation mandated programs. She's joined today by her New Jersey-based colleague, Lauren Marcus, and we're so pleased, Lauren, that you were able to join us today as well to really give that New Jersey perspective. And so thank you, Nancy and Lauren, for being with us today and sharing your expertise. And I will now turn the meeting over to you.
Thank you, Angela. Good morning, all. My name is Nancy DeLogue. Some of you may know me from prior presentations to Drugs Don't Work New Jersey. I really am grateful to have my colleague Lauren today. I've been a shareholder in the Washington, D.C. office of Littler for quite a long time. Lauren is, as Angela mentioned, in our Newark office, Rutgers student all the way, New Jersey through and through. And Lauren, I think, will be able to put a little bit of detail into the presentation about, a little crystal ball reading, a little bit of what's happening on the ground with marijuana in New Jersey today. And she obviously has insight into what some of our business clients are thinking, doing, and preparing for changes in the law that we expect to have happen. So without further ado, we have a lot to cover today. I'm not going to read through the agenda, but you will see it on your screen. These are the topics that Drugs Don't Work New Jersey have asked us to cover today. Evidently, the recreational marijuana law changes are top of mind for everyone, but in order to make sense of what is happening, we are going to very quickly cover what's going on or what is the current status of the law with both recreational and medical marijuana. And then we'll have a chance to talk about, what, if anything, you'll be doing to get ready for this. As you're probably aware, marijuana legalization is coming to New Jersey. We're not quite there, so we're going to start with a brief overview of what the law is today. I don't know if any of you have seen that out your backyard, but you may see that up the street pretty soon. Right now in New Jersey, especially if your Drugs Don't Work members, you know that there's no statute or rule governing drug testing or even drug-free workplace issues like employee assistance programs. But dating back to the late 80s, the New Jersey Supreme Court, in a case called Hennessy versus Coastal Eagle Point Oil, has issued guidance, right, on what they expect an employer's drug testing program to look like, and importantly, what they expect from a privacy perspective. When does an employer have the right to be concerned about employees' use of what I'll call illegal drugs, right? And when do individuals have sort of the right to be left alone because their drug use is not going to impact their employment? Obviously, when you frame it like that, you can see why that case is still going to be very important today if we're thinking about recreational marijuana and how it impacts your day-to-day policies. What has the New Jersey courts, what have the New Jersey courts done or permitted in the past? What do they consider as relevant for the employer? Just to really distill it in a way that's not particularly fair to the good jurists of the New Jersey Supreme Court, in order to drug test employees or applicants in the state, it is generally advised that your interest as an employer has to outweigh the interests of the employee. So your need to know whether someone is using marijuana, in this case, and to take steps perhaps to address that use must outweigh what their interest in privacy, what they do perhaps in their own time. Generally speaking, you can manage expectations of privacy by allowing, letting employees know what you expect, telling them why you think it's important. You can always prohibit people from coming to work impaired and under the influence. All of that is sort of where it is. And importantly, that case is the case that said that New Jersey will not allow blanket or universal testing of all employees, but it will allow random testing for individuals in safety or security sensitive roles. Anything where someone's impairment might really pose a risk to themselves or others. That Hennessy case is the case that laid down that law the first time, right? So in the private sector, employers can um, can test under these circumstances. And this is not a marijuana testing law, right? This is a law about testing anyone for illegal drugs. Similarly, since we're talking about privacy, the New Jersey Supreme Court acted based on a recognized public policy in favor of privacy of the individual. Your testing methods can't be more intrusive than is necessary to obtain a valid result. And so we don't hear about this very much anymore, but in the late 80s, I would, sometimes hear stories where the employer marched everyone into like the conference room, gave them a plastic cup and told them to, produce a sample. In certain types of workplaces, that is not the sort of privacy that the New Jersey Supreme Court had in mind. As you'll see, the law on testing for marijuana is poised to change. And so it's helpful to kind of give you this background. Because the law on testing for marijuana is likely to change and it applies only to testing for marijuana, this may result in confusion about your testing program for other types of drugs. So it's good to have this background as to this, right now, regardless of what happens with marijuana legalization, this I do not expect to change for other types of drug testing in the state. And of course, the Americans with Disabilities Act can limit, when you can conduct alcohol tests as medical exams. So that's kind of the status quo. Now, we have medical marijuana in New Jersey. I'm Compassionate Use of Marijuana Act. It's actually the Compassionate Use of Medical Marijuana Act, or it was originally, and it was revised last year. Medical cannabis users do have employment protections in New Jersey now. Originally, the statute was silent, and it was unclear whether an individual would have status or work protections, right, from private sector employers simply because they were using medical marijuana. For example, the employer could say, well, that's all very well, but we can't put you in this role, or we are a drug-free workplace. The changes to the law made it now so that employers cannot refuse to hire or employ, you'll see the language there, discipline or discharge any individual or discriminate against any person in marijuana who uses marijuana or in the marijuana program solely because they're a registered qualifying medical cannabis patient, right? So the law now does say, okay, you're probably going to test positive on a pre-hire test if you're a medical marijuana user. And if you have a card, we can't just say, oh, sorry, we don't hire people with cards. On the other hand, the law still allows you to prohibit people from coming to work impaired. And it does allow employers to take adverse action in appropriate circumstances, either because the medical marijuana use perhaps poses some kind of obstacle to either doing the job safely, or because it's inconsistent with a contrary federal law like the U.S. Department of Transportation regulations. Or even if you test positive. So if you come to work impaired and you get a reasonable suspicion test, the fact that you're a medical marijuana user is not kind of a get out of jail free card under the existing law. It's a little challenging, right, for the employer to make their case, and it would be for the employee as well. What changed mostly last year, there's a couple of things. First, the law was silent as to protections. This law actually created these new procedures, which I assume most of you are following now, but if you, especially if you're based out of state and are dialing in, you may have missed this. Now, if someone tests positive for marijuana in the state of New Jersey, the employer is supposed to send them a notice saying, hey, you've tested positive for marijuana, setting aside the whole medical review officer process. You have the right to contest a positive result. And we send you a letter saying you've got the right to contest a positive result. You can do so by either, right, providing evidence that you've got your card, your medical marijuana card, or an authorization from a healthcare provider. Maybe you haven't received your card yet, or both. I sometimes see employees or applicants will submit, and the individual can request a confirmatory retest, and a confirmatory retest of the original specimen, which was always on our best practices list. You know, if somebody wanted to get on their own expense a confirmatory retest to make sure that there was nothing wrong with the testing process itself, that is now not a best practice, but actually a requirement for individuals who test positive for marijuana. So it's kind of where we are under the New Jersey Compassionate Use of Medical Marijuana Act. But that's not the only law that is relevant to you in New Jersey if you have a medical marijuana user, because while this act was being challenged, you know, did it provide protections? Did it not provide protections? Plaintiffs' attorneys and individuals who felt that they had been treated unfairly because of their medical marijuana use were also pursuing claims that they had been discriminated against on the basis of their disability or medical marijuana use that treated a disability under the New Jersey law against discrimination. And so that's, you know, you can be wrong or, you know, under more than one law. And that was sort of the argument that we were, that we were dealing with. And I think last March, we saw some of the first cases come down. Well, just last year, right as the pandemic kicked off, the New Jersey Supreme Court actually decided this case, Carriage Funeral Holdings, or Wild versus Carriage Funeral Holdings. That's just a screenshot of an update that Lauren actually led, finding that setting aside the specific protections of the state's medical marijuana law, individuals who engage in the lawful use of medical marijuana may also have a claim under the state's the LAD, as we say, the law against discrimination. And that means that let's say you cannot accommodate someone in a particular role because of their use of medical marijuana. Maybe they want to drive a regulated, a truck for you, and the U.S. Department of Transportation regulations say they cannot. Rather than saying, oh, sorry, we can't employ you here, you may have an obligation to at least explore with them whether there's another role available, whether they could stop using the marijuana and use something that would be acceptable for them to be a truck driver, things like that. So there's more than one law to think about now while you're talking about medical marijuana. So with the Wild case, and I'm just going to touch on that briefly because I know you want to talk more about what's coming. That case had actually been dismissed in the lower courts, sort of as a facial challenge to, like, you can't sue me under this law, as opposed to here's what the facts say. And so the holding of the case was that the plaintiff had stated a claim, and the Supreme Court sent it back to the trial court to hear evidence. That was an interesting case in that although the individual, Justin Wild, who brought the case, had been involved in an accident which led to the drug test or the disclosure that he used medical marijuana. It was not really a post-accident drug test under their policy. So what we don't know now, right, is sending this all back for further analysis if if his job duties included apparently driving the hearse in the funeral procession or perhaps other vehicles, and the law says that it shall not be construed to permit a person to operate or be in physical control of any vehicle while under the influence of marijuana. I think there'll be a question as to whether, if someone is a medical marijuana user, the employer can assume that they will nevertheless not be under the influence if they perform job duties that involve the operation of motor vehicle, or if the employer has to somehow try to prove that the individual was impaired while actually doing their job before they can take action. So these are some some open questions that we still have out there. Now, because they sent that back, I haven't heard anything more. Lauren, do we know if that case is still pending, or if Justin Wild and the Carriage Funeral Company reached some sort of private resolution?
I do not know. That's actually a good question. And we actually have been getting some great questions from people relating to this that I think we could answer. So some people have been asking how long medical marijuana shows up in your system, for a test, if you're not allowed to discriminate. My understanding is that it really varies. Is that right, Nancy?
Yeah, it does. I actually was attending a toxicology presentation yesterday, so I can renew my knowledge on this topic. But it depends on how you used it and how much you used it. I think what most people are concerned about is urine tests, or obviously hair tests. You can't even get a piece of hair to measure drug use until a couple of weeks after at the earliest. But urine measures metabolites, right? It's what has been ingested or consumed in some way and is being metabolized out of your system. And so having marijuana metabolite in your urine sample doesn't suggest you're currently impaired. There's also this weird thing about THC molecules, and that's what we're looking for when we talk about marijuana. That they're fat soluble, so they're known to bind to people's fat cells, right? And then when you burn that fat cell, which we all hope to do during the month of January, typically, it's released into your bloodstream and then is flushed out. That can happen long after use if you are a long-term regular heavy user. And so, when we're talking about marijuana being illegal, the fact that you used marijuana some time ago might be relevant to whether you were impaired and a reasonable suspicion test was necessary, but it wasn't really a big deal. It was still like, well, even if you weren't impaired, it was illegal. Now that we have people who are, as kind of, you're getting a marijuana card because you expect to be a regular user of marijuana, right? So whether you're impaired or whether it's built up in your system, it's really hard to say. So the two tests that are capable of really detecting recent use are blood tests, which are generally not very popular because they involve a blood draw. You need a registered phlebotomist. It's a medical exam of some type. Or an oral fluids test, which is the saliva test, easy for employers to administer. That one will measure marijuana that is sort of circulating in your bloodstream and in your saliva. And can only detect the use within about the what I've seen is at the greatest level, like 24 hours, but usually it's just for several hours. So that's not going to show impairment, just like a breath alcohol test doesn't show impairment. It measures how much THC is in your bloodstream at a given time, but it can be a more useful approximation of when the use occurred and whether the drug is actively moving around someone's system such that the employer could be concerned about that. So we're seeing that in some of the other jurisdictions, in particular, employers turning to oral fluids tests to help show that somebody not only was permitted to use medical marijuana, but probably was impaired because, one, there was a reasonable suspicion of impairment, and they had a test that showed that whatever use they had engaged in, it wasn't like, over the weekend. It was enough that they had enough circulating in their system at that time. We're going to talk a little bit about what different states would do. But for example, the state of Oklahoma does protect medical marijuana users, just like New Jersey. But it also says if you have a certain amount of marijuana in your system during the workday, and they give you a cutoff level, then the employer can presume that the individual was impaired. So there's a little more certainty there. We don't have that here yet.
No, and one of the other follow-up questions is, in light of this case, how does this all work with discrimination in hiring if a person's main function of their job is driving? And
Right.
That's a great question, and I apologize, but there's not a great answer yet in New Jersey. Even if your main function is driving, a positive test if you're a medical marijuana user just isn't sufficient to do anything.
Yeah, that's a real challenge. I mean, most of the other jurisdictions have that are sort of ahead of New Jersey, because when I say most of the other jurisdictions, the ones that have employment protections have generally, provided carve outs for individuals in safety sensitive roles. So that might be sufficient to deny the job. I think that's exactly the question that the Justin Wild versus Carriage, the Carriage Funeral Holdings presents, which is, was he in a safety sensitive job such that the employer could just say, look, we just don't feel safe putting you behind the wheel. If God forbid something should happen, we might be liable. So that's what we're waiting to find out. As you'll see in a minute, there is some possibility, right, that this will become even moot in New Jersey as we look toward the marijuana legalization law. But it's a great question. We don't really know. So I want to talk a little bit about, what most of us are here for, which is the New Jersey referendum on marijuana legalization, and what follows from that. On the screen here is just a copy of the proposed constitutional amendment, which was in fact passed in November, right? Well, everybody else was looking at, who would control the Senate, et cetera, and so forth, or who voted for whom in the presidential election. New Jersey enacted this, and it's interesting, right? Because this is a constitutional amendment. It means it's going to be legal. It does mean, as you can see, subject to a state sales tax, and the legislature plays a role, right, in deciding how to do this. But this is the full sort of text of what the the thing said. So it was called question 1, and it was that was what it was. And Lauren and I have talked a little bit, like, what does it mean to make it a constitutional amendment as opposed to a state law? Lauren, you've said to me, for one thing, they gave the decision to the people instead of the legislature. Do we know beyond that what this will mean going forward?
No, it's really interesting. Typically constitutional amendments are, more protected than other things. So, I mean, effective supposedly January 1st, the New Jersey Constitution said, the use of cannabis is legal for adults over 21. But as we'll discuss further, the fact that there's absolutely no legislation right now supporting this or implementing it, New Jersey's really in an uncharted territory in terms of what that means and what to do.
Yeah, and I think right after the election, you put out a sort of another update, right, saying like, okay, this passed, but that doesn't mean marijuana use is just definitely okay, like right now, right? So yeah, all right. So let's what is the impact, right, of the constitutional amendment on the workplace? The text has nothing. There's nothing there. Now that there is some sort of constitutional rule that says that marijuana should be lawful. Some states like Colorado and others, Colorado comes to mind because they had a marijuana challenge under that law, protect employees and applicants who engage in lawful off-work activity. And they say, you employers cannot take adverse action against people who engage in lawful off-work activity. And typically those laws sort of started out as smoking laws, right? Like you can't refuse to, and we have one here in New Jersey, you can't refuse to hire someone simply because they smoke or use tobacco products or choose not to. We had employers who are, and in other states, you are still allowed to do that. And so some of those employers will, decide not to hire people who use tobacco products, and they, they cite wellness programs and other things like that. But right now, there's nothing here. However, there is kind of a line of cases, and I kind of alluded to it with respect to the Hennessy case that governed drug testing. There is a pretty robust thread of, judge-made law interpreting the public policy of the state, and public policy arguments. If marijuana is now, no longer lawful, we may see some challenges to, employers who say, well, it may be lawful, but that doesn't mean I, as a private employer, have to accept that. We may see some public policy arguments saying that, marijuana users should be protected, at least so long as they use away from work, right? You can't just have a status-based discrimination claim under that. So recreational marijuana is coming to the New Jersey workplace. That's a screenshot, Lauren, of the article that you and Dylan did, basically saying, hey, question 1 passed, but hold this place because we need, the legislature must enact legislation to implement the legalization and decriminalization of marijuana. So despite the constitutional amendment, in case you are getting arguments to the contrary, marijuana is not currently available for recreational use in New Jersey. And the legislature has to adopt legislation effectuating the change to the Constitution. As Lauren's going to tell you in a minute, the legislature doesn't seem to be able to get out of its own way, but just to give them a little credit here, this is particularly challenging where the underlying conduct, right, the marijuana use and sale and everything remains unlawful as a matter of federal law. How is this going to work? And how can they do it in such a way that they don't, kind of bring down the wrath of federal regulators and legislators, or things like that? How are these two laws going to exist side by side? So before we move forward, I just wanted to show you, here's New Jersey on the map with the little asterisk. This is recreational marijuana legal status by jurisdiction. And this is a very, I won't say it's a dumbed down chart, but it's just an overview, right? These are the states in green, right, of course, where marijuana is available for recreational use. Some of these states allow the legal sale and regulation of cannabis and cannabis products, and some have not and have simply decriminalized the use, and they allow people to grow their own marijuana. For example, Washington, D.C., people can use marijuana, but there are no shops selling marijuana. There's medical marijuana shops, but there's no shops available, like liquor stores kind of thing. And so these are all kind of different even within themselves. And so this is where, New Jersey's kind of joining the East Coast contingent there. And where among these states are there legal protections for workers using recreational marijuana? But okay, wait, no, we're talking about jurisdictions that these are the jurisdictions that offer legal protections for workers who use medical marijuana, okay? What we're talking about is, are there jurisdictions that offer employment protections based on someone's recreational use of marijuana? So here is the list of jurisdictions that offer employment protections to individuals who use marijuana for recreational purposes. If I can get my slide to advance. It's blank. Oh, wait, there's Nevada. Wait. Do none of those states offer protections for employees who use marijuana recreationally? Nevada has a protection. Nevada says you can't test pre-hire unless the job is safety sensitive. But if you test new hires within 30 days, the employee has the right to present you with additional information. Okay, and you can make a decision about that. It's a little bit like the medical marijuana law in New Jersey now, right? If somebody who has a medical prescription, they can present information. So, but only within the first 30 days. New York City has a law that says don't test people for marijuana pre-hire unless the job is safety sensitive. But you can decline to hire them or discipline them if they use marijuana after hire. Illinois and Maine, you may recall Illinois legalized marijuana just last year. Those states have a rule that says you can't refuse to hire someone simply because the applicant says they've used marijuana as permitted by law. But you can decline to hire them if they test positive. So that's it. So, going back to this slide, of all of these jurisdictions, none of them have protections that limit an employer from removing an employee who uses marijuana recreationally. These are all, they can decide we're not going to hire you. We can ask you once you're hired, can we decline to employ you in this role, et cetera, and so forth. And that has been okay. So all of these
Nancy,
jurisdictions.
this is Angela. We just have a question coming in that I think before you move forward, and we're getting a lot of questions on this, if there are any occupations that are protected or specifically prohibited from using marijuana, including doctors, nurses, law enforcement, pilots, teachers, people who work with children, for both medical marijuana and recreational use of marijuana.
So nationally speaking, there are sort of two groups of people who are prohibited from using marijuana for any reason. One is transportation workers. That is people who drive commercial motor vehicles, drive the Amtrak trains, pilots subject to FAA regulation, transit workers like New Jersey Transit operators, some pipeline workers, and those who work in nuclear power plants. That's it. So,
Okay.
yeah, right. So like in California, just to come back to my slide, recreational marijuana has been available in California for a long time. Teachers are not allowed to use marijuana there if their school district says they cannot. And no one can use marijuana if their employer says they cannot in California. The way that has worked out is that in California, if you care, right, about marijuana use, you will test for it and you will not hire people who test positive, or you will discipline people who test positive after hire. And if you want to get some drug-free employees, you might have to pay a little bit more, right? So they kind of let it work its way out through the economics of the system. With the exceptions that I just showed you, all of these jurisdictions allow the employer to have a zero tolerance policy once someone is hired, except for, it looks like, New Jersey. So folks, we're headed into a world of unanswered questions right here, right now. We're going to do our best to answer questions about the pending marijuana legislation in New Jersey and the impact it will have on marijuana in the workplace. But I'm going to tell you, there are going to be employment protections for people who use marijuana, and they are unlike anything else in the entire United States right now. So here we are. We have something that is the NJ, the New Jersey Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act. And just a quick note, Lauren is going to help me explain how we got here with that. But this bill has passed the legislature at middle of December, and the governor was expected to sign, but he has held it up, or he originally held it up because he wanted some additional penalties for people who are under 21 users. Before I ask Lauren to kind of give us the status of where that stands, I do want to say New Jersey calls marijuana cannabis for purposes of the modernization, the constitutional amendment, and also this Modernization Act. I'm using marijuana throughout our presentation because cannabis can be a bunch of different things. It can be CBD products that don't contain any THC. For example, there are a lot of cannabis products that don't contain THC. THC is the psychoactive ingredient. It's the thing that employers test for, and it's kind of what makes marijuana, if you will. So, there may be a lot of places where you can use CBD, including under federal law, as long as it has 1/3 of 1% of THC in it. That's not what we're talking about here. We're talking about, a marijuana product or a marijuana plant that contains THC. Like you can buy vapes that are 95% THC right now. So just so you understand why I'm using the term marijuana instead of cannabis here, it's because cannabis can be a perfectly innocent kind of plant that doesn't have any impairing impacts, and which frankly isn't even unlawful. And we want to talk about how this law interacts with those laws that have made marijuana lawful. So somebody just texted, but pharmaceutical CBD contains at least some THC, which can be found on drug testing. It has to, by law, contain less than 1/3 of 1% THC, and it has to be grown actually under federal regulation, which is very difficult. So there's not a lot of regulation there. The truth is, if you use something with 1/3 of 1% THC for weeks and months, there's a theoretical possibility that it could cause a positive drug test on a urine exam, but that is not likely to happen. What we typically find is that people are using either marijuana as CBD and hoping the CBD will excuse them, or they will be using CBD that has THC in it. Some of the CBD that is marketed out there as, improving health, it's not a medicine, it's, it's a natural product. And so it doesn't get a lot of regulation. And those are considered to be contaminated, frankly, under the Food and Drug Act if they have too much THC in them. But we have done that. So every time we get people who say, "Oh, I'm a CBD user, that's what's caused me to test positive," we are typically, if people want to spend the time and money, able to get a workplace expert in there to say, not using that bottle of CBD, must have been using something else in addition. So that is just saying I use only CBD is the get out of jail free card right now for marijuana users. They try and convince their employer that they never used marijuana or anything that had THC in it. So possibly they did use bad CBD, but possibly it's just being used as an excuse as well. Might have to actually do some toxicology exams on that bottle. So back to where we are with this legislation. Governor Murphy was expected to sign. I was waiting for him to sign. Lauren told me he was going to sign. Drugs Don't Work New Jersey folks told me he was going to sign. And then Lauren, what happened? Lauren calls me. She says, "This is not happening."
I have to tell you, so going back, when in November when the election happened and we issued that article saying, hey, it's not legal yet. We agreed to amend the Constitution. That's effective January 1st. The Attorney General came out and said it's still unlawful until then. We need all this legislation. We have, as most of you know, we have Democrats everywhere. We assumed that this was going to go through, and there was a last minute breakdown. So the New Jersey legislature, both houses, passed a bill A21 in the middle of December. Governor Murphy was expected to sign. To the best of our knowledge, everyone had been on board. And last minute, he said he wanted penalties for users who were under 21 years old, similar to, if you drink underage or people who smoke under 18, he wanted there to be fines to, somehow limit or discourage underage use of recreational marijuana. So the interesting part is that the legislature seemed on board with this. They prepared a very lengthy, quote unquote, cleanup bill. I believe it was over 50 pages. We thought that was going to go through. And then last minute, they said, never mind, we're not on board with these changes. The governor will have to either sign or veto the law that we already gave him, and we'll move forward from there. So most of the changes that they were making had to do with penalties for people under 21 who were using recreational marijuana. There was I think one cleanup item that could potentially impact employers, but not really for our purposes. It was just regarding who could provide training for these worker enforcement agents, for lack of a better word, who could tell if someone's impaired at work. We'll talk about that later. But so as of right now, we're kind of in limbo. The governor hasn't done anything. I believe he has until February to make a decision. And now we're just kind of in a state of limbo, unsure of where to move on.
Yeah, and then to be clear for all of you who are listening to this, Lauren and I thought that there might be a vote, a signature or a vote on this cleanup bill on Monday, i.e. yesterday, and that obviously didn't happen. So it could all change again quickly. But for right now, what from the takeaway is this is the bill that has passed both the House and the Senate in New Jersey, and the hangups don't seem to have anything to do with the employment provisions. So we feel like, this is a pretty good, estimate or prediction of what you're likely to get. It's a question of when they work out the other issues that are holding them up, at least as far as we know right now. So what does the proposed law say about marijuana in the workplace? It's going to be hard for Lauren and I to explain how this is going to work in practice because as drafted, the law really doesn't make a lot of sense. So I know you're going to have questions, sort of bear with us as we move forward. If this law, this A21, you said, Lauren, becomes law, right? Employers will not be permitted to refuse to hire any person or discharge or take any adverse action against an employee with respect to compensation or any other terms and conditions of employment because they do or do not use cannabis products. So that will be unique in the nation, and it won't just be a hiring decision or an employment decision. But notice, let's say you know that somebody uses marijuana and you can't take adverse action against them. That means you can't, for example, move them to a non-safety sensitive role, right? Because that would be a term and condition of employment, or pay them less or something like that. So that is, that's the sort of big thing there. You won't be able to take adverse employment action against an employee solely because they have tested positive for cannabinoid metabolites, THC or marijuana, right? There is no exception to this rule. The only exception is that if you have to maintain a drug-free workplace by virtue of a federal rule or contract, that is, you have a federal, we're thinking, transportation workers who are subject to federal regulation, and have to be subject to drug testing as a matter of federal law, will continue to be covered under that federal law. Otherwise, you can't take adverse employment action against an employee solely because they tested positive for cannabinoid metabolites. I get a lot of people asking about marijuana legalization. What about if we're a federal contractor or a federal grant recipient? What about the Drug-Free Workplace Act of 1988? Without predicting what would happen in potential hypothetical law, it may not help federal contractors here or federal grantees, because that rule typically says you have to prohibit illegal drug use at work. It doesn't require any testing. And you can prohibit marijuana use at work under this law. You will be able to do that. You just won't be able to prohibit people from coming to work with marijuana in their system. It's a little different, right? So, okay, how is this going to work? Again, if Governor Murphy signs it, that will become law. But even should that go forward, which we now know is uncertain as to when that might happen, some of the provisions, like the employment provisions addressing impairment and testing, have a delayed effective date, right? So it's going to get passed and recreational marijuana will be legal, but then certain parts of the testing process that are changed by this law will go into effect a little bit later. So we really don't know, for example, if this law was to be signed into law tomorrow, what that means for drug testing between now and the time the commission that will be appointed by the commission and the regulations that will be issued by the commission go into effect. We won't really know whether in that space you'll be able to take adverse action based on somebody's impairment at work, or how you could even demonstrate that somebody was impaired at work. So we're looking for that information. I referenced this commission, the NJCREA MMA does have a process that will create a commission that is charged with adopting regulations to implement the law, and the regulations that commission will publish have to come out either 100 days after the law's passage or 45 days after all members are appointed, whichever is later. I think Lauren said that we've identified some of those commission members already, but the full commission hasn't been identified or named, probably because, right, that would only give them 45 days, to get going, and they want to make sure they have as much time as they can. Now, to be fair, this commission is not it's not really charged with adopting regulations to implement the employment provisions of the law either. This is the whole thing. The sale of marijuana, who gets it, who can sell it, what kind of licensure is required, who can get into the industry, what should the tax implications be. So that, that's only one of the things I expect they'll be asked to look at. So impairment, performance, and drug testing under this law, what is that going to look like? Can you continue to test for marijuana? That's the big question. Yes. There is nothing in the law that says you cannot test for marijuana. In fact, this statute has portions that say you're going to be able to test for marijuana in a range of circumstances. It's arguably broader what the New Jersey Supreme Court said in Hennessy. So, for example, it's not unlawful to test for marijuana, but that doesn't mean you can do anything with the results. This is one of the parts of the law that doesn't make a whole lot of sense. I do not know why the New Jersey legislature says, for example, you could do random testing and in fact scheduled testing but you can't act on those results unless you can also demonstrate impairment. So,
Well, and especially, just
Yeah,
to
Jill.
jump in, the
Yeah.
pre-hire testing. It specifically permits pre-hire testing, but has the language Nancy showed that you cannot not hire someone based solely on a positive result. You need, as we're about to go through, the observable signs of intoxication at work, but someone doesn't work for you yet. So the law really leaves a lot of questions for employers.
Yeah, Lauren, that's a really good point. And I'm just going to say, like, why would I tease you like this? It's because some employers, no doubt, will continue to test under their existing program. They're based in Nebraska. They've got 12 people in New Jersey, and they don't figure out that they can't act on because of marijuana use until after they've tested a bunch of people. So in that sense, the law from an employment defense perspective, great. Maybe you tested them, I don't know why you tested them, you can't act on the results, but the fact that you asked for the test is not in and of itself going to be penalized. So that could be helpful, right? But like once you get those test results and then you think, okay, well, normally we would decide not to hire you. And the applicant from New Jersey says, you can't decide not to hire me based on this. Haven't you looked at our new law? Then the employer has sort of another chance to go back and get it right, perhaps. It's not particularly helpful. So this statute, this is language that was sort of, cut and paste from the draft that says you can test upon suspicion of marijuana use, right? Well, the employee is engaged in work, right? So you have to have reasonable suspicion that they used at work, not that they used it in the parking lot before they came into work. But if they use it in the parking lot, you might have observable signs of intoxication that would allow you to test. You could test following an accident, or as I mentioned, at random, when scheduled, pre-hire. And so this is not necessarily exactly, consistent with what Hennessy says, right? But this would be just for marijuana. And so again, if you're doing marijuana testing and cocaine testing, you might have to kind of spend some time figuring out how those two work together. This is the actual language of the statute. An employee shall not be subject to any adverse action by an employer solely due to the presence of cannabinoid metabolites in the employee's bodily fluid from engaging in conduct permitted by the legislature. That is, if you use marijuana, cannabis, as they say, you shall not be subject to any adverse action simply because the cannabinoids are in your body fluid. And I assume that means urine, oral fluids, blood. So what else do we need to solely do the presence? Well, the employer can take adverse action if the employee is also impaired by marijuana at work, and a drug test result can help show impairment. What is weird about this is that, it's not going to work for those of you who have testing programs. It's not going to work the way you think of. One of the Oops, hang on. My slides have sort of hung up here. Go forward. What is a drug test? I'm not being facetious here. This statute redefines what a drug test is. Okay, so a drug test, if this statute becomes law, a drug test will allow employers to take adverse action following a positive drug test for marijuana if your drug test meets this definition. It must include scientifically reliable objective testing methods and procedures, that seems reasonable to me, such as blood, urine, or saliva, and a physical evaluation in order to determine an employee's state of impairment. So you could do a random drug test and a physical evaluation to see if someone was impaired by marijuana, and you could take adverse action on that basis. Okay, so a drug test in New Jersey under this law, it's just a little strange. You think of a drug test and a physical evaluation. They're kind of merging them into one thing. You can take action following a positive drug test. A drug test includes the physical evaluation. And what is the question, right? Like, so what is that? What kind of physical evaluation? How is that going to work? Well, the physical evaluation has to be conducted by an individual with the necessary certification to opine on the employee's state of impairment as a result of marijuana use. And then if you have that information, you can use the results of that drug test together. So great. Who is an individual with the necessary certification, and who will get that? And are we going to have one of these in every workplace? No, somebody put in the question box, MRO? Nope. The commission, right? Remember, this commission that hasn't been named yet by the New Jersey legislature in consultation, you know what? That's a typo that I put in. That's the Police Training Commission, not the Policy Training Commission. The police, right, with the commission are going to prescribe standards and regulation for a workplace impairment recognition expert certification. And people who will make these physical determinations will have to get education and training to detect and identify an employee's use of or impairment from cannabis or other intoxicating substance, and for assisting in the investigation of workplace accidents. So 2 years ago in May, I attended a Delaware bench bar conference panel where discussing the state's medical marijuana law, and among the panelists was a police officer who obtained a certification as an impairment recognition specialist. He was one of 9 such officers in the entire state. We don't know what the training will require. It might be quite difficult to become certified. At present, there are no certification requirements and no one is certified to perform that role. So even if it becomes available quite soon, it'll be quite a lot of time, right, before employers can take action once this law is passed. And again, we don't know what's going to happen in that sort of 180-day period between the time that becomes law and the time we have regulations certifying people. So that'll be interesting to see what happens. So what should you do? Updating your policy and procedures. This is just a fun picture of some marijuana products, extra strength THC Stony Patch Kids. Assuming that the law is enacted without changes to the employment provisions, I'm going to go really kind of quick through here and then we'll try and answer specific questions. It's going to be okay to prohibit the possession and use of marijuana at work and during work time. That's good news. It's going to be okay to discipline workers who come to work impaired. But as you just heard, that's going to be pretty challenging to prove. It's going to be okay to drug test for marijuana, but it's not going to be okay to act on the basis of off-work marijuana use that's permitted under the New Jersey law. That's sort of the easy stuff. It's not going to be okay to act on the basis of a positive test alone unless that test includes a physical examination by a certified impairment expert. Presumably the impairment expert has to agree the person looked to be impaired and be able to document that. We don't know what evidence will suffice to establish impairment. There are no, this is getting a lot of, I see questions in the box about police officers and teachers or whatever. There are no exceptions to this marijuana use rules for workers in safety sensitive roles unless subject to federal regulation. There's literally no carve out for anyone in a safety sensitive role. There's no carve out for public workers. There's no the way it's drafted, everyone in the state of New Jersey will have a constitutional right to use marijuana and will also have employment protections under this law, unless you can demonstrate that they are at work impaired. It's pretty unclear even now whether the positive test result can be used to discipline workers who operate motor vehicles with marijuana in their system. And we talked about this at the beginning of the seminar. It does say, and this is again a quote from the draft, nothing in the law is intended to allow driving under the influence of cannabis items or driving while impaired by cannabis items, or to supersede the laws related to that. So presumably it will still be criminal to operate a motor vehicle with cannabis in your system if you're impaired by that. New Jersey is not one of the states that has like a cutoff. Like when Colorado passed its marijuana legalization law, they decided 5 nanograms per milliliter of THC in your bloodstream would be under the influence for driving purposes. We don't have that in New Jersey. In fact, right now, mostly proving impairment, and I'm not a criminal attorney, mostly getting people, it all comes down to whether they are, observable behaviors by the police, as I understand it. There's not like a quick and easy test that will help you with that. So that it's unclear whether the employer can say, I can't put you behind there's no carve out for that unless the employer knows that the person would be driving under the influence. How do we keep them from behind the wheel? Which gets me back to why I don't know if Justin Wild's case is going to be kind of moot, right? Like as to whether, if he could have done it using recreational marijuana, what does it matter what the protections under the medical marijuana law are? We'll see. It's okay to prohibit the use and possession of the cannabis products at work and during work hours. We don't know. I hope that means during meal breaks and rest periods. I believe it does. I think there will be interesting to find out. Two bullet points there. Lauren and I are already getting questions from our out-of-state employers. We don't know whether you must excuse out-of-state residents who work in New Jersey who use marijuana, right? Because they won't be using it. Can they use while they're in New Jersey before they go home to Pennsylvania? It's also unclear whether New Jersey residents who work out of state and whose marijuana, like if you're a Pennsylvania employer and you've got a New Jersey resident come to your workplace, I think probably the Pennsylvania employers will still be able to say no, to people who test positive under their law, but we don't really know that yet, how those will intersect. Educating workers about your expectations and any changes to your policy will be crucial. It's really important for your employees, I think, to understand what you can do, what you would like to do. Certainly, the minute recreational marijuana becomes available, a lot of people think it's okay to have it in their pocketbook and in their car and bring it to work with them. And it's going to be hard to know what is marijuana or a cannabis product because there's like little gels and things. But I think if nothing else, if you'd like to maintain a drug-free workplace, you want to make that clear about whether they can have it with them, whether they can use it during the workday. With respect to testing, I don't want to end here, and we're going to open it up to all kinds of questions that you have, but I don't know whether it will be worthwhile to continue testing for most of the employers in New Jersey, or if they will just abandon testing for marijuana because this is just not only unknown, but depending on what it takes to prove that someone's impaired, it may be too difficult. So I'm going to pause here and ask Angela, Lauren, some of you have had time to look at some of the questions. We have a little extra time. We can wrap, we're getting close to the end. What are the questions we're getting?
We're getting a lot of questions about whether anyone other than like Department of Transportation can limit the use of marijuana, specifically teachers, police officers, medical professionals. We're getting a lot of questions regarding whether you can prohibit the use of marijuana. The answer, as far as I'm aware, is you can prohibit people from being under the influence at work, but there's no exception, regardless of what job you are, for the off-duty conduct at this time.
Yeah, I think that's right. I mean, it may be easier for employers to say, wow, Dr. Smith appears to be impaired every time she comes to work. I think it's cannabis use, but since it's going to be really, really difficult for me to prove that, I'm just going to fire Dr. Smith for other reasons or find some other, certainly discipline people for bad behavior, but that there's no per se profession that's exempt from this as far as I can tell.
Nancy, Lauren, are there still, or will there be opportunity in drug policy, in workplace policy, to make provisions for this for an independent private business, or even a school district or a municipal office? Is that something you can address?
So what do you mean, like to address it in the policy, to describe what the?
Well, will there still be ways of prohibiting marijuana use in the workplace for private businesses if they include it in their policy?
They should include in their policy that they can't come to work with it or use it during the work time, and not come to work impaired, but saying like, we're a drug-free workplace, you can't use or test positive. No, I mean your policy is not going to trump like a state law that's enacted pursuant to a constitutional amendment. I don't believe so.
Okay.
Yeah. I will tell you that in Illinois, they came close to adopting some employment protections for people who used recreational marijuana. And the business community didn't really see it coming, and they passed the law in the spring of 2019, and the law was going to go into effect January of 2020. In November of that year, the Illinois legislature went back and revised it so that they could have, a zero tolerance policy once somebody was employed or if applicants tested positive. So I don't see any movement for that to happen in New Jersey, but it could still happen. But as I said, that's why it was so important for us to let you know, like the hang up here seems to be, what should the penalties be for people who are under 21 who use marijuana? And as I understand it, the concern and the thing that blew up that discussion was a question about whether the, by having any penalties at all, the law would have an adverse impact on minority communities. So, that's a really different issue. Let's see. Any mention of THC levels and what level will be considered under the influence of an employee is tested? I don't see, that's a good question. I don't know of any movement in New Jersey to suggest that you have to be over a certain threshold for THC in one system. It may be possible that individuals who are receive the training, right, and recognizing impairment will be also educated a little bit on the toxicology there, but I will tell you it would have to depend on the type of test. For example, we already discussed how urine tests don't really show present impairment, they only show recent use. They might show very heavy recent use, but oral fluids tests, for example, might be more helpful. Mostly you're only going to test positive on a urine test for 72 hours after you use marijuana. But if you're a chronic regular user, and then you go cold turkey, it can build up in your system and cause a result a couple of weeks later. So it's really a question, when we were talking about people casually using drugs on the weekend, or like, well, no, they're not going to test positive on Friday if they last used, on 2 weeks ago at the Super Bowl party, like we used to hear. That's not going to cause a positive urine test. I think the whole situation has shifted. People are going to use every night, right, or every day, or very, very regularly. So it'll be interesting to see what happens there.
Yes, it will be very interesting. I know we're coming to the end of our time. We have launched a poll for all of our attendees. If you could give us some information. I have one last question, and then if there's any final comment, Nancy or Lauren, that you would like to make. The question is, do all of these workplace policies, do they have to specify if this marijuana, these marijuana provisions will be applicable to youth under the age of 18 or even young adults under the age of 21. I know that's being discussed in the State House right now. Lauren, not sure if that's something that you can address.
So do I understand the question is, what if you have employees who are under the age of 21 who use marijuana?
Yes.
Okay.
That's the question.
Yeah. So the constitutional amendment only legalized it for people over the age of 21. And so, Lauren, let me know if you disagree. I would think that unless they were using it medically as permitted by state law, you could still, say we're not going to work with people under the age of 21 who test positive. What do you think?
I would agree. As far as I know, that should be fine. We'll know more once we see a final bill at some point.
Right.
But I think that should be fine.
Well, let's just wait.
Right.
So we know what they were worried about. That wasn't what we were worried about, right? So hopefully they'll work out their issues and then maybe revisit some of the concerns of the employer community.
All right, thank you.
Yeah.
I just, before, if you have any, I just want to make one comment to all of our attendees. I know we're running out of time and that many of you have still had some questions that we weren't able to address. We'll send you an email following this event with a copy of the presentation. But if you have any questions that you'd like to see if we can get an answer to, you can email Bill Lillis. That's bill@drugfreenj.org. We'll put the information in the chat and also include it in an email to you as well. Nancy, Lauren, thank you so much for being with us today and sharing, your expertise on this very complicated issue right now, as we're still all kind of in limbo. I'll just turn it back over to you if there's any closing comments you'd like to make.
Thank you for having us. We thought when we set this up, of course, we'd have something a little bit more clear, but it's certainly exciting and important to know. I put our contact information there. You probably saw throughout the presentation, we put up period like legal updates, and if any of the listeners need legal updates beyond the good information that you guys, you can always subscribe to our updates on all things employment law. And you just get on an email list there. We're really just, grateful for the opportunity. Thank you. We'll do our best to stay on top of this and bring you any updates and clarifications.
All right, thank you so much. And I know there's a lot of interest in having additional webinars on this topic once the law is signed and passed. I know, Nancy, we talked about perhaps doing something again together at that time. And Lauren, I hope that you'll be able to join us as well. We have an event scheduled for early March. You saw the information in the chat feature for Drugs Don't Work in New Jersey members, and I hope that you can all attend. I want to thank everyone for being with us today. Again, thank our speakers, and I wish you all a good day and good health. Be well.